Let us look into the right to equality which has been guaranteed by our constitution. The part 3, that is a part on fundamental rights, starts with the definition of state, that is article 12. Article 12 applies to all the fundamental rights. Fundamental rights are guarantees against state action. So, the question comes, what is the meaning of state? Now, here article 12 says state includes government and parliament of India. State includes government and the legislature of each of the states, and legislatures of each of the states, and also the government and parliament of India. So, it specifically states. Now, here when we speak of other authorities, we have to see that it is used ejusdem generis. That means, as is applied in first, second and third, that is the government, parliament, government and legislature, and all local authorities. So, the other authorities also should be the authorities which are in line with these three definitions. So, in several cases it has been held that an authority which comes under the state, or when we say that it is a state, it should have something where the state has a control, or the state is able to regulate, or it is something which is under the state, or it is an agency of the state. So, the definition of state is to be known if we have to enforce the state action or enforce the fundamental rights against the state action before the courts. Coming to the next article, article 13, it speaks about how the fundamental rights are protected against the laws, or when a law is made which has something which violates the fundamental rights, how do we go about it? So, here first of all 13 subclause 1 says that all laws in force in the territory of India immediately before the commencement of the constitution, if they contained, if or as far as they are inconsistent with this part 3, that is the fundamental rights, then to the extent of that inconsistency, that law will be void, which means that whenever a law was in force before the commencement of the constitution, there were laws and they have not been repealed. Some laws are continued, but at that time they had something which was inconsistent with part 3. Now, the fundamental rights chapter is there. So, if that thing is there or some part is there which is inconsistent, then that part will be not considered as it is void. 13 subclause 2 says that further, after the commencement of the constitution, if the state makes any law, so it says the state shall not make any law which abridges or takes away any of the rights which is conferred by this part, that is part 3. And if any law is made in contravention of part 3, then to the extent of that contravention, that particular law will be void. So, it gives a guarantee that the state shall not make a law in future which violates our fundamental rights. In case it does so, that part which violates the fundamental rights under part 3, that part will be void to the extent of the contravention which has been committed by the state. This is 13 subclause 2. Now, when we say law, a law cannot be made. What is the meaning of law? There are several meanings of law. It may be a general law or it may be a law made by a statute. So, how do we define a law and how do we approach the courts in case a law is made and whether that is a law first of all? So, 3a, 13 subclause 3a says what is a law? It says law includes any ordinance. So, ordinance can be made by the governor or by the president. Any order, any bylaw, any rule, any regulation, any notification or any custom and usage which has the force of law within the territory of India. So, in case of the violation of fundamental rights, any of these they are considered as law. If that law violates the fundamental rights, it is void. This is 13(3)(a). Now, coming to laws in force. What is the meaning of laws in force? So, here 13 subclause 3b says that laws in force includes laws which were passed by legislature or any other authority before the commencement of the constitution which has not been repealed. That is law in force. So, though that law may be in operation or may not be in operation in certain areas or in particular areas, that is the meaning of laws in force, means it was already enacted before the constitution, it was not repealed. That is the meaning of laws in force. So, this is the clarification of laws, the definition of state, and then it says that any of this which is against the fundamental rights in part 3, that is void. Now, let us come to the first right, fundamental right, that is right to equality under article 14. This is a very, very precious fundamental right. Right to equality means that all are equal, and the wordings of this particular provision has to be noted. The state shall not deny to any person. So, not only citizens, to any person, he may be a citizen or a non-citizen. The state shall not deny to any person equality before the law and equal or the equal protection of the laws within the territory of India, that is article 14. So, when we look at article 14, we see that it is a negative concept, because it says state shall not deny. When we bring in a negative concept, it is a complete restriction on the state from denying to any person equality. Now, why are there two terms, equality before the law and equal protection of the law? What is the meaning of both of these terms? When we look at equality before the law, it means that all are equal before the law. The law is considered in a wide sense as a general law of the land. That means all persons are subject to the ordinary law of the land, and there is no special consideration for any single person. So, here all are equal before the law. It shows that the rule of law principle is dominating, or it is followed in our Indian constitution. So, law rules, not men. This is the meaning of equality before the law. Whether he is a president of India, whether he is a richest person, whether he is a poorest person, whether he is a farmer, whether he is a person on the road, everyone is equal before the law, and they are subject to the same law, and they can be present before the courts whenever the courts require. So, that is the meaning of equality before the law. When we come to equal protection of the laws, it has a very particular meaning. Here, equal protection of the laws. What do we mean by laws? Laws means all the laws which are enacted by the legislature. So, when enacting the laws by the legislature, the state has to see that everyone is given equal protection. There is no differentiation between the people. But that does not mean that laws are equal means that there should be one law for everyone. It does not mean that law should be uniform. For example, if we come to that extent, to give an example, if we say that there is a income tax law which taxes everyone equally, when we say that, it will be not equal protection, but it will be injustice, because a person who earns more has to pay the same tax, a person who earns less has to pay the same tax. So, this is not equal protection. When is equal protection given? So, it is given when equals will be treated equally. That means, we know that people are not born equal, they are not placed equal in society, there are different status, there are different problems. So, when for particular persons who are equally stated, the law will be equal for them, that is, it is treated equally. Those who are unequal should be treated unequally by giving them special protection. That means, there is a classification to be done, a reasonable classification can be done under this provision, classifying people into different categories so that each person is given equal protection. So, we can call this as protective discrimination. Though there is a discrimination, it is not for the purpose of giving them a discriminative treatment, but for protecting them. So, it means that reasonable classification is permissible. In several cases, this reasonable classification was questioned. What is the meaning of reasonable classification? How do you classify people? Can you just classify on the basis of a caste or a community, or on the basis of gender? What is the meaning of reasonable classification? So, here there were several cases which came up before the court. One important case was Air India versus Nargis Mirza, when an air hostess was asked to leave her job because the Air India rules provided that a person who gets married, or a lady who gets married and she has a child, has to leave the job. Now, she questioned this on the ground of article 14, as there is a as there is a discrimination. So, in this case the reasonable classification test was looked into by the court. When we classify people for a special treatment, now when we say that ladies cannot do this job, so we are classifying in men and women, whether that is reasonable. So, in this case the court said that reasonable classification should be in such a way that there should be intelligible differentia, that is the things which are differentiated should be able to be understood by our intelligence. The second ingredient of reasonable classification is that when the classification is made, this differentia or the different categories which are made, they should have reasonable nexus with the purpose of the statute. So, why are we making this law first of all? For example, why are we making the income tax law? For the purpose of collecting revenue. So, that purpose should be served by the classification. So, when we are generating revenue, we are also not causing injustice to people. We are classifying on the basis of income, not on the basis of something else. Suppose for the income tax purposes, we classify on the basis of their caste, then it does not become a differentia which is reasonable nexus with the purpose of the statute. Here it is, the purpose of the statute is for income purposes. So, the differentia will be based on the income. Suppose we classify for the purpose of giving them protection. For example, women and children, they are given protection under certain laws. So, there the law which is made, when the classification is made, those grounds should have a purpose or should have a connection with the purpose of the law for which they are made. So, in this case the court said that classifying a woman and a man and saying that this differentia is there for the purpose of the statute. What is the purpose of the statute or the Air India rules is that a person should be efficient in her job. So, if you say that a woman who has a child is not efficient in her job or she is not able to perform well, that is not proved, and the court said that it is something which is against the natural ability or natural that is the nature of the woman, and you cannot insult womanhood by making such a law. That was a landmark case. So, there are several cases where the court has looked into this classification test. So, whenever a law has to stand on the test of classification, it has to see that where the protection has been given to that person, whether the people are or the citizens are protected under that law, whether the classification which is made is reasonable. For purpose of classification, there may be any number of people, even a single number, even a single person can be a separate class if he needs the protection. That class, they can make a special law and they can give him protection. For example, for those who are handicapped, they make special laws. For children, they make special laws, or for women, there are special laws. For example, providing them conveyance from their workplace at night. So, there are certain laws. There you can have a criteria or a classification. That classification should be intelligible, it should have reasonable nexus with the purpose of the statute. The classification is permitted under Article 14. When we see these provisions, we see that Article 12 to 14 consists of the first right, that is of course 12 and 13 speaks about the introduction part, that is the definition of the state and the definition of the laws in force, what is a law, and Article 14 speaks about the first right, that is the right to equality, and it specifies that everyone is guaranteed equality before the law and equal protection of the laws within the territory of India. I hope you have learned something from this video. If you have liked it, please share it with anyone who you think would be interested. Please leave your comments and I would be happy to reply to them. Do subscribe to get more information on everyday law and legal studies. Thank you.